Is recorded just so you're aware. And without further ado, we'll get started. So this is how to get Medicaid without losing your home. We have Jay Sherrill here. He's the managing attorney of Sherrill Law PC, and he will be running the webinar. And again, if you have any questions, just put them in the Q&A and we'll be happy to assist you with them. So here's Jay, everyone.
Thank you, Courtney. Thank you. Thank you, everybody, for joining us today on this lovely afternoon. Super excited to be delivering this webinar to you today, because this is one of the most common misconceptions that we get from both potential clients themselves, advisors, that we can't get Medicaid if we have too much money. We can't get Medicaid if we have a house, or simply resign to the fact that if we get Medicaid, that the state is going to take the house. And the sad thing is that it's such a big misconception that then leads people to not take action when they had the opportunity to do that, and then almost sometimes becomes a self-fulfilling prophecy because they didn't take the actions necessary to protect their home. So then they did actually end up having their home either disqualify them for Medicaid, or the state taking it after they did go ahead and qualify for Medicaid. So the whole idea behind today's webinar is to tell you how to get Medicaid without losing your home. Now, today's webinar is going to be strictly legal information. I have prepared a few little case studies, no advice there. And the information that we're going to give you today is how you can actually protect your home. But we're going to talk about three main strategies. And as you'll see, that there are going to be ones that either resonate with you as a good option, or ones that may be an appropriate fit directly for your needs. And obviously, we won't be able to give you that advice in today's webinar, but we would be glad to answer questions that you have. As Courtney mentioned, do go ahead and drop those into the Q&A as we go, although we will save all of those questions for the end, so that we can move through the material and then answer your questions in a meaningful way. But if you're anything like me, if I wait until the end of the webinar, I will have forgotten my question. So go ahead and drop that into the Q&A as we go. So who's excited and ready to get started? If you are, just go ahead and drop a Y into the chat for me. We will go ahead. Thank you. Awesome. Fantastic. All right, so let's dive in. So what you're going to discover in this webinar, we're going to talk about three main strategies to protect your home. Now, this is not the only three strategies, but these are three major strategies that we often use. And going back to where we started, right? So the answer to the question is, can I actually get Medicaid and protect my home for my family? And the answer is yes. So we're going to talk about those three strategies. We're also going to talk about the common traps that we run into with home protection, because not all of the strategies are created the same. They have each have their pros and cons, and how they fit into your plan. And we're also going to talk a bit about trust as a good solution to protecting the house. And no, trusts are not just for the Rockefellers, right? The trusts are commonly the way that someone uses to protect an asset for Medicaid purposes. So this webinar is for you if you're frustrated about not knowing your options. I think one of the most common things we see, and Courtney can attest to this, is that either we don't know our options, or we think that we're resigned to having lost the home into Medicaid, or simply not qualifying. Or quite frankly, the other option, whether it be from Google or you name it, neighbor, friend, brother, sister, who happened to go through a similar situation, and this is what we did, right? And so almost frustrated in knowing about not knowing what the options are, or sometimes information overload. This is also for you if you're worried about long-term care costs. Now, that's really what Medicaid is, what we're using it for. So Medicaid is this program that the middle class uses to pay for nursing home care and home health aides. I mean, there's really three ways that you can pay for that care: either out of pocket, and that solution, you have to reach into your pocket and pay money to provide for this care. Now, that cost of care is about $8,000 to $10,000 a month for a home health aide, and upwards of $18,000 a month right now for a nursing home. And so that is an expensive way of doing that. Another option is long-term care insurance, and then this can be great for someone who has the means to pay for the premiums. Typically, we see traditional long-term care insurance not being offered as much these days, but often a hybrid policy that is like a life insurance policy with a long-term care rider, or an annuity that does carry a long-term care benefit to it that can then be used to pay for that cost of care that we talked about. But we often find that those premiums are too much for many people, and so Medicaid becomes that payer. And so if we're worried about how we will pay for that care in the future, not leaving a surviving spouse impoverished, not leaving our children with nothing, then this is a good webinar for you. And this is good also if you want to be able to protect your home. And also, we'll talk about some solutions briefly about how you can protect other assets for your family and also leave it behind in a clean way. So that way, your family is not left having to go through probate or having to go through complicated estate proceedings. So I'd like you to take a second and imagine that you could wave a magic wand and have your hard-earned assets. Often our largest asset for people that are considering Medicaid planning is a home here in New York on Long Island. It's not difficult for our home, maybe even one that we bought for $50,000 in 1960, to be worth over $500,000. It also leaves you the ability to leave a legacy behind for your family, letting them start out with your goals in mind, leaving either just a lump sum of money behind or leaving it in ways that can be meaningful to accomplish the legacy that you desire. And choosing your beneficiaries instead of the state, simply not planning, for example, can result in a scenario where the state has a lien against your home, essentially making them the beneficiary of your estate. Because if the lien needs to be satisfied before paying off the house, or distributing the proceeds from the sale of the house, then what happens is, who's getting the money? The state's getting paid off first. So just to give you an idea of how this can help in a particular circumstance, we had a client, Joe, who was married. Joe is married to Jane, but Jane got sick and needed a nursing home. Now, the nursing home that they needed to go into, right, was costing $15,000 per month. Okay, so they came to us for an asset protection session, and this is how we examine particular circumstances for a client and advise them on an asset protection plan. And for them, it was a two-step plan. The first thing, for example, was an outright transfer of the house to a spouse. Now, that is one of the ways that we're going to talk about today and how we can protect the house from Medicaid. But that wasn't quite enough. Now, that actually, interestingly enough, they had actually heard that already, that they could transfer the house to the spouse, right? House to the spouse. It's all over Google. The friends tell them that. But then what happened next was that we transferred the house to a trust because there's complicated recovery laws. So they were able to get eligible for Medicaid. The state started paying the $15,000 per month. Thankfully, they came to us only about a month in after spending $15,000. But if they were misinformed, you could imagine how quickly that could add up. But then even after that, because the state maintained a right of recovery against the house, we then made an additional transfer, an additional step to protect the house by putting it into a trust. Ultimately, they ended up saving the equity of their house, which was approximately $600,000. Before we dig into the material, just a little bit about myself and the firm, and I thank Courtney for that wonderful introduction, but who the heck am I, right? So my name is Jay. I'm managing attorney of Sherrill Law PC. We are a boutique estate planning and elder law attorney office here on Long Island, and this is all that we do. We made it at the outset for this firm to dedicate our time to the complicated and often very nuanced areas of estate planning and elder law. That may mean in one morning I'm meeting with a client talking about estate taxes, which we have talked about at webinars before. And those are different concerns that a client has when they are concerned about Medicaid. And so even within that, jumping over, for example, from the Internal Revenue Code over to the Social Services Law is a big jump. That we decided we would not, go into doing matrimonial law and divorces and custody proceedings. We just focus in our niche area. This is myself and my wife when we were very young, and this is why we do what we do. Each one of the members of our team, including myself, are about family. So this is us. We actually knew each other when we were real young kids. Here we are as flower flower girl and ring bearer in her wedding. And then we got married. I'll save you the whole story much after that. That's my wife when I was a traffic control officer for the town of Southold. This is actually how I started my legal career. Sounds kind of weird. How did you get jump from a traffic control officer directing traffic at the Strawberry Festival to becoming a lawyer? But I was working for the police department, went back to school to get my criminal justice degree, and I took a class in criminal law, and I absolutely loved it. It was the first time in all of my studies that I was able to spend an enormous amount of time studying something, and it felt like minutes had passed by. I had a passion for it. I ended up moving away from criminal law, though, and helping with families in estate planning because that's just the direction that I went. But that's the level of effort it takes to kind of get to speed on this stuff. This is my wife and I at our wedding. And look, this was really the reason I started getting into estate planning, was because we were getting married, figuring out how to scrap together our wedding funds, and I was going to law school and taking out debt. And I saw how my parents had inherited money and how that money had been set aside in a way, or spent in a way, that wasn't necessarily advantageous for family wealth planning, or helping the family continue to grow into the generations in the future, where those funds may have been spent in other ways. Also saw a fight between my father and my uncle over that as well. So saw how that could have been left behind in a better way. But most importantly, having seen my grandmother go through this level of care, and I was only at 10 or 12 at that point, my grandmother, and they were private paying for AIDS, not knowing the options that they have. This is my first daughter being born, and she and my second daughter were the reason that we started this firm, because I had this beautiful one here wanting to help other families start to protect for their children and protect the legacies behind. But the real reason I started this law practice was, this is Lily. Lily was born at 31 weeks premature. She was born at 31 weeks. She was born about 12 weeks premature. And, it was just an eye-opening experience. So I got the benefit of that experience from that was to be able to come out and say, look, here's the things that matter the most in life, and I'm going to help people affect the change in their world that they want to. And seeing how fragile life was, and seeing this fighter, who that is her there, that was last fall in her Halloween costume. She's in the back. That's me, my wife, and Eliana now. And so that's really the reason why we do what we do. And so I'm here to help you. And so these laws are complicated. We often see people getting, misguided advice from multiple different sources, as well as, unfortunately, attorneys that tend to dabble in this area of practice, not knowing all of the implications of all of their moves, and not knowing these rules are a disadvantage for an individual, because having to cut a check that was unnecessary for $150,000, $300,000 worth of care sometimes is a huge disadvantage to that family over time. It essentially becomes an additional hidden tax, where maybe this family might not be concerned about estate taxes, but you know what? This cost of long-term care can be a real drag on a person's hard-earned assets. And the sigh of relief, and I know Courtney can see this because she helps many of the families, just a sigh of relief you see when this care is secured, when the plan is implemented. People just know they have a peace of mind, and I just like to see that time and time again, right, Courtney? Yeah. So let's talk about how you can make sure that your loved ones are taken care of. So in this webinar, we're going to talk about the three strategies we talked about. First is outright transfers. The second is life estates, and the third are Medicaid asset protection trusts. Okay, we're going to break each one down separately, talk about the differences between the three and the pros and cons, and then we will take your Q&As at the end. So first, let's talk about outright transfers. Now, the major benefit of the outright transfers is that they're simple. And this is often why we end up cleaning these up, because people will either do it themselves because they can download a deed off the internet. It's not hard. I mean, it's ink on paper. It's about knowing what ink to put on the paper and when. People will download it, or they'll often call an attorney and ask them to do what it is that they want to do. The attorney having this, I don't know why, it's not something that we necessarily do here ever, but they will just follow the directions of the client and not really stop to ask why the client is doing what they're doing. And then at the end of the day, it's not the end of the world for the attorney. Why? Because the client called up, said, I want a deed transfer. The attorney did the deed transfer, charged them, closed the case. It's done. But no one stopped to think and talk about the planning of it. And so we often get those that come across our table. Now, the major problem of the outright transfer are that it's irrevocable. Okay, is number one. We'll talk about some others, but the big thing is the only really pro here for the outright transfer is that it's simple. And we'll talk about some places where an outright transfer is absolutely necessary or the only option. But here, if we're getting proactive planning and proactive advice, the only benefit of the outright transfer, it's simple. When I say it's irrevocable, if I transfer a house to children, for example, to get it out of a client's name, the client can't ever get that transfer back unless the kids sign off on it. Now, that sounds simple. I'll show you a case study about where we helped a client with this issue, or I should say weren't exactly able to help them with this issue because of the irrevocability of that transfer. But even more so than that, when you make an outright transfer, you lose the right to live in your home. So if you've ever seen articles in the paper about someone getting thrown out of their house after transferring the house to their children, for example, and you wonder how that could possibly happen, that's because there's this concept of this right of occupancy. And when you make an outright transfer of your home, you lose that right of occupancy. So that runs always, no matter what, runs the risk that you could lose your right to live in the house. Now, this could manifest itself in your kids actually evicting you from your house, but that's kind of drastic, right? So no, everybody says, not my children, never. And I agree with them. I hope that's always the case. But what if the child got into a car accident, was uninsured, has a judgment against them, and this creditor wants to collect against their assets? Well, if you've made an outright transfer of the house to that child, they are going to be able to collect against that house. The way they would do that would be through a foreclosure proceeding. So now you could have a foreclosure proceeding against your house for a judgment that's not even against you because you gave away your right to live in the property. You will also lose your property tax benefits. So most of the clients that we help with these situations have property tax benefits. They're on either Star or Enhanced Star. They have vets benefits. They have a reduction in how much they're paying the town for their taxes. And by transferring the house outright, then they will lose those property tax benefits. So to plan for the possibility of needing home health aides or nursing homes in the future, and now to guarantee the loss of property tax benefits, if this was the only option, I think people would often take that trade. But if there are other options, then maybe we should evaluate those. Outright transfers also carry negative tax consequences beyond property taxes. This speaks to capital gains taxes. Now, the capital gains taxes can be a big problem in these outright transfers because of this concept called the step up in basis. Now, if you've been reading the news, this is something that's currently under attack or proposals for changes. At this point, I think we need to proceed as if that step up in basis will continue to be there. If it does end up being reduced, or eliminated, then we'll have to take a look at how that affects everybody. But everything right now is currently in proposal planning. And even in those proposals, the proposal provides a $1.5 million step up, basically. So you can step up $1.5 million of assets. So it will be there. So we need to be preserving these step up rights. And what that is, I'll show you in a case study of how that can affect your estate. So here's an example of the tax trap that people run into by making an outright transfer. So Jody needed community Medicaid, and she read online or spoke to her neighbor that she needed to give her house out of her name, right? And so what's the simplest way of doing that without having to hire an attorney, for example, right? She just went online, got a deed, transferred the house to her children. Now, Jody had purchased that house 40 years ago for $100,000. Now, that house was worth $700,000. Because of this transfer, she gave that $100,000 basis, okay? This low number, the amount that she purchased the house for right here. She gave that basis to her children. And when she passed away after the house was now worth $700,000, her children would have had to pay taxes on that $600,000 of gain. Now, that the capital gains rate was at the time of 25%. So that is a big tax bill that didn't need to have been paid. That was really only incurred because of the outright transfer that now lost the step up in basis. The way it would have been handled, and we'll see how this works in the additional other options that we have, is that instead, if we had preserved the step up in basis, Jody's children would have gotten all of that gain that happened during Jody's lifetime to be erased. They would have gotten a new basis to be the date of death value. And for the purposes of this case study, let's say that that date of death value was the $700,000. Now that $700,000 would be the new basis. If they sold it for $700,000, they'd owe $0 in taxes. Okay, so that is a big, big difference in terms of where it was. Now, thankfully, she was healthy at the time. We were able to help reverse that, put the house back, and then do some of these other additional strategies, and ultimately save them that $150,000 tax bill. Now, so what do you need to do, right? So if you want to examine this option, right, the simple could be nice, but we have to examine the cost basis. So if we have an asset that is highly appreciated, this is one that we should not really be considering about using the outright transfer unless we have another reason to do that. For example, a lot of today's talk is based off of the idea of planning. Actually, all of today's talk is based off of planning in advance. So this is planning before needing nursing home care. Outright transfers do become somewhat helpful in emergency Medicaid planning, where someone has waited until the moment they needed care in order to do the planning. And if we don't have the ability to make exempt transfers for Medicaid purposes, if we don't have the ability to use a Medicaid trust at that point and need to rely on exempt transfer, like one to a disabled child or one to what's called a caretaker child, someone who's lived with the Medicaid applicant for 2 years before needing a nursing home. These are things that we can do within the look back period, maybe our only options, and there we have to take these concerns. Second is considering issues that may frustrate the plan. Because of the irrevocability, a lot of what our advice is focusing on what happens if someone needs to get that house back. We talk about what if the judgment happens, what if this child passes away and now grandson owns it. But really, what all this planning is dependent on having to get past 5 years before really seeing the benefits of it. So if you don't get past the 5 years, those are things that can frustrate the plan. Often we need to undo the plan. And if, let's say, a child has passed away and now the owner of that interest of the home is a minor, there's no way that minor can sign back the house to the client. So that way we can now get Medicaid. So what happens in that scenario is that the client actually can't get Medicaid because they're penalized for that transfer, yet we can't get the transfer back to cure it and come up with a new plan. The other thing I would do as well, if you're considering an outright transfer, would be to look at the property tax deductions and make a decision. If you have other options, is this the one that we want? Because the property tax deduction is minimal. Okay, so let's talk about the second solution then that we have. So the second solution that we have is what's called a life estate. I like to think of this like a hybrid model. And these were incredibly popular about 15 years ago. But since a law change around that time in 2006, the life estate has fallen by the wayside, and we'll tell you why. Now, the reason is because the life estate, like the outright transfer, does not involve needing a trust. So it's somewhat simple. It can be done on a deed. And what happens, though, is that it will also protect the right to live in the house. How does it do that? Well, we think of real estate ownership. I don't even know if we really think about it. Back to law school, I thought about it, right? It's not really an all or nothing approach. Like I have this bottle of water here, right? Well, you can't see it on my screen background there. I have a bottle of water there. I can give you the whole bottle of water, or I could give you half the bottle of water. I could just give you a drop of the bottle of water. You can actually separate your property ownership the same way. And what we end up doing with a life estate is that we transfer the future interest in the house, but also keeping the right to live in the house. So now we know that if we've done a life estate, that we can't be thrown out of our house. Okay, because of the creditor issues that we talked about, or the eviction issues that we talked about with the children. So let's use that same example. transfer life estate. So I reserve the right to live in the property for the rest of my life. Now I transfer the future interest to my beneficiaries, to my children. Now they get that accident, no insurance, judgment. Judgment wants to collect against the house. They can't collect against the house. They can't collect against the house as long as I'm living, I should say. As long as I'm living and retain that right to live in the property, I cannot be foreclosed on. Now, they could collect against the house after I pass away as it relates to that person's interest. Okay. It'll also protect the step up. Why? Because I've retained that right to live in the property for my remaining life. I will enjoy the step up in basis. So the life estate can now avoid those capital gains issues. Okay. It can also preserve the property tax benefits. So basically, the life estate can eliminate all of those negative tax consequences, all because I retain that right to live in the property. But the major downside of the life estate is that it's still irrevocable. We're going to talk about a case study about a mistake a client made and thinking how this could work out. I'll show you some of the scenarios where it presents a problem. But the life estate can be a good fit for the right client. The reason why they were so popular about those 15 years ago was because at that time, the look back for nursing home Medicaid, okay, and at that time, there was only a look back for nursing home Medicaid. Now there's a look back for home health aides, that's 2.5 years, and there's a nursing home look back period of 5 years. Now, at that time, there was no home health aide look back, but there was a look back for nursing homes. And what the look back said at that time was that life estate transfers like this one had a look back period of only 2.5 years. Meanwhile, look back periods for the asset protection trusts, which we'll talk about as our third solution, those had a 5-year look back period. So sitting here and thinking about the pros and cons, the life estate having a half of the look back period was a good option for many people because they wanted to get a lower look back period and they could see the value of their investment in this planning a lot sooner than they could have with a Medicaid asset protection trust. But the law changed in 2006 to make it so that trusts and life estate transfers and outright transfers, it doesn't matter, whatever the transfer is, needs to be done 5 years prior to needing to nursing home. And now with the new look back period for home health aides, 2.5 years before needing home health aides. So now removing that benefit is what makes a difference in the concepts. So let's just talk about this client that made a big mistake. I mean, that's really what happened. And this goes back to that same relationship that we talked about before. So Betty wanted to get her name out of her name for her house out of her name for Medicaid purposes. So what did she do? She started reading online about life estates as an option. She thought that was a good solution, and it could be in the right circumstances. And at that time, we were at that period where there was a 2.5-year look back period for life estate transfers and a 5-year look back period for nursing home transfers. So she read about that. She found an attorney to do a limited scope engagement for her. Simply prepare the deed I've told you. Now, this is super dangerous because this is so dangerous because what happens is the client wants something, the attorney delivers it. And in a limited scope engagement, that's exactly what they were asked to do. And they did it, but no one really helped them with the comprehensive planning about the consequences of those actions. Because when the client came to us down the road, what happened was after she had a falling out with one of her daughters, who was one of the beneficiaries, we call remaindermen, they wanted to change the estate plan. And as I explained to her, and unfortunately in this particular case, we weren't able to help her, was that the daughter that she's now seeking to disinherit because she had a falling out with her, she needs that daughter to sign off on her own disinheritance. Because in order to really revoke this life estate deed, we needed to do a new deed. We needed to get both the children to return that future interest to the client. Okay. Now the client came to us, actually called Courtney, I believe. She called and said, I need to update my will. How, what's it going to cost to do my will? I think the same approach, like the client reading about something and directing the attorney. We say, well, hold on, that's not how we operate here in the law firm, right? We need to sit down for a consult, because what you're asking me to do, I can do for you, but it may not actually have the consequences and the effects that you're looking for. And when she came in and we took a look at the deed, and we saw that was glaring, because deeds like this pass outside of a will. The deed is what controls. So had we just said, yes, we'll change her will and disinherited daughter would have still gotten the house. And we tried to help her. Naturally, then we sent out the deed with the transfer docs, a nicely worded cover letter, and we sent it to this to be disinherited daughter. And of course, I mean, I can't imagine what she did with it. Probably crumbled it up, threw it out. We certainly never got it back. And unfortunately, we weren't able to help this client with that. There was no relief through the court system, because that's what she wanted to do. She gave away a future interest, and she can't change her mind now. So she wasn't able to change that. So then let's talk about this option and deciding what it is that you want to do. Now, first, you got to consider the what ifs. So look, if this is not something that concerns you or minimally concerns you, then look, you could do a life estate deed. This would have the middle ground of the three options to be able to protect the house from Medicaid. But it doesn't always do the best planning, because it doesn't allow, for example, if a person goes into a nursing home, to sell the house now, because we don't need the house, and the house is only bringing increased cost and expense to the house, because the person who, the client, right, that was applying for Medicaid, still has a value to that home, and that money that's that value to that home is still attachable. You also got to consider if there's other assets that you're looking to protect just beyond the home. Now, we can talk for a long time about other Medicaid planning tools for other assets like retirement assets and pre-need funeral planning beyond the topic of today. But if we're looking to preserve other assets like investment account or a CD, money that savings, you can't really do a life estate with those, right? And so the trust becomes a nice option that can accomplish multiple things with one stroke, so to speak. And also think about the irrevocability. Now, think about the irrevocability, because the irrevocability is exactly what we went through with Betty, is that if circumstances change in the future, can we actually get this back, or will this frustrate our plan? If we tie that in with the first case study, even if we had done the life estate and we needed to get the house back because someone needed nursing home care within the 5-year window after making that transfer, what would have happened there is that we would have needed the children to sign off on it. And let's say that one of the children had passed away. Now we need minor grandchildren. Minor grandchildren can't consent to this. So we're really stuck with this unless all the stars align to allow it to be changed. Now, that brings us to our third option. And the third option, and we often find after having reviewed each of the options, the one that many people choose is the Medicaid Asset Protection Trust. Now, what the Medicaid Asset Protection Trust does is it will basically do everything that the life estate did, plus more. Okay, so the life estate, we said it would protect that right to live in the house. So does the trust. Will it protect that step up in basis? Yes, it will. So we maintain our security in living in our home, and we can also protect and preserve those unnecessary, in that example of $600,000 house, an unnecessary $150,000 tax bill. And we can also protect our property tax benefits. So this is a great option like the life estate, but it removes that issue of irrevocability. Now, you might ask, because if you've done some Google searching, right, you'll see that the Medicaid Asset Protection Trust itself is actually what's called an irrevocable trust. And that often scares many people away from considering this option. But I urge you to consider this option, because the irrevocability here in a properly prepared Medicaid Asset Protection Trust, and they're not all created the same, right? It's ink on paper. It's about knowing what ink to put on what paper and when. The irrevocability in a trust that we would prepare for a client is not irrevocable at all. It says it's irrevocable. What does irrevocable really mean under the letter of the law and the provisions that we've put into the trust? It's that the person that created the trust doesn't have the right to revoke the trust by themselves. They need the consent of two key individuals, or two key classes of individuals. One is trustees, and these are people that are in charge of the trust. For example, you think about a corporation has a CEO, same concept for a trust, has a person in charge of it that is called a trustee. And the other class of people that you need to consent to the change or to the revocation of the trust are the beneficiaries. Now, the beneficiaries are, like in the corporation, right? Shareholders, the people who will end up with the money down the road, right? So after you pass away, the terms of the trust will leave money to beneficiaries. So again, how does that make it revocable? And what do you mean? It still says it's an irrevocable trust. Well, if you need the consent of those people, we carve into that trust that you have the right to change the trustees and the beneficiaries at any given time. Let's think that through again. That's like saying if I have a nuclear submarine and I have that I don't have the power to launch it because it's irrevocable or unlaunchable. I need the backup of two other people to have keys to consent to that as a safeguard. But I get to choose who has the key holders at any given time. I get to give them to Courtney now because Courtney will sign off on it for me. Oh, Courtney won't sign it. I'll give it to any one of you. Who's going to sign off on it, right? I will give it to the potted plant in the corner of the room if they could sign off on it, right? So while in a nuclear submarine, that might be a terrible idea. We might have all sorts of checks and balances. In trust planning for Medicaid purposes, we like it. We like it because it gives us that ability to be, I'm going to put it up here, irrevocable, right? Because it says it's irrevocable, and it is irrevocable because the person that created it cannot revoke it themselves. They need the consent of those other people, but we reserve the right for our clients, the people that created the trust, to choose those other people. And so what that does is it gives us flexibility. So irrevocable, flexibility sound like they don't go together, but here they do. Like, because the reason is because it's not really irrevocable. So here's an example of a client who didn't plan early enough and how this irrevocability component of the Medicaid Asset Protection Trust really gave them the benefit of both worlds, the ability to now revoke this trust as needed. So Hannah and Jake, again, are married. I've chosen married couples often for the planning because it simplifies some of our options. Medicaid planning is often like a game of chess. And so we have less options and less moves ahead of us when we have one spouse, but doesn't mean the game's over. But when we have a husband and wife, we have a lot more options. So they came to us in 2020 and transferred the home to a Medicaid Asset Protection Trust. We examined each of the three options with them and how it fit into their family. They wanted to protect their house. We're scared of the irrevocability issues with the other two options, and also had some other funds, liquid funds they wanted to protect. So having one vehicle to do all of that in one place was a great fit for them. The issue, though, we ran into is they came to us in 2020 to do that. And 5 months later, after doing the transfer, Jake had a stroke. Jake had a stroke, and then he needed nursing home care. And the very transfer that we had made 5 months earlier to the Medicaid Asset Protection Trust, by the terms of the Medicaid laws, we're now making him ineligible for Medicaid because of that gift. That whole planning is dependent on getting past the 5-year clock. So getting past the 5 years from the transfer before we see the benefits of the Medicaid protection. So here, in order to cure that and secure the care to cover the now accruing $18,000 monthly bill so that Hannah wasn't left with absolutely nothing, we had to transfer the house back. And in order to do that, we needed to revoke the irrevocable trust. We did that, and we qualified for Medicaid. We did all of that without needing anybody else's assistance. We knew if we ran into any issues with a predeceased child, a beneficiary that was non-cooperative, reluctant, we were able to move forward without them with the stroke of a pen on our client's behalf. We then qualified Jake for Medicaid. Now back to our analogy of the chessboard. Now we have other moves that needed to be made, was what's called second stage planning. Because remember, we're not going to talk about recovery in a great detail today, but the state does have a right to recover against Hannah's assets when both Hannah and Jake pass away. And the way that we can get that done is to now put it into another trust. So in 2020, unfortunately, he had a stroke, moved the house out and the assets back out of the trust. And now we are doing second stage planning for that surviving spouse, the healthy spouse. So that way the Medicaid can't come after the house after they both pass away. And all of it was done without negative tax consequences. All of it was done without the scare or the possibility that the person would be stuck For example, we go back to Betty, and Betty needed to do this. Betty would have been stuck. And if Betty and Jake were married, Jake would not have been able to get Medicaid. The bill would have been accruing at $15,000 to $18,000 a month, while daughter, who is non-cooperative, is essentially holding them hostage. And here the client wasn't stuck because we used the Medicaid Asset Protection Trust. So what do you need to do to enact the trust? Let's think about the advantage of the trust. Now, the con, obviously, as you see, that wasn't on that slide, was it's not simple. This becomes an incredibly customized, incredibly thought through document that fits both your personal needs now, a great deal of thinking about how we actually put assets into the trust and how we structure it in the most effective way. And then ultimately the beneficiaries of that plan and how that will carry on, maybe even in trust if that's what a client desires, for multiple generations. So the trust does become a very nuanced approach. It's not quite as simple, but all of the advantages that we saw, and mainly knowing that we can protect our right to live in property. If we had put in, for example, income producing assets, we can also have a right to income while the principal itself is actually protected. And that we maintain those keys, going back to that nuclear submarine example, we maintain the keys to be able to revoke the trust at any time. If you've now thought about the trust as a good option, as that fits your needs because of its benefits, you need to consider trustees. Now, trustees are the people that are in charge of the trust. You can name one, you can name two, you can name one. I think we saw one the other day had 9 people on as trustees. Not something that we would necessarily advise, although it does create the issue of how many chefs do we have in the kitchen. But the trustee is an important role. You need to have someone who's going to cooperate with you, because yes, while you do retain the right to fire that trustee at any time, from the outset of the planning, we're not looking to put someone in that's not going to listen to what we need. We have those provisions in the trust as a way to safeguard, but that should not be the plan to appoint someone that we don't trust. It's right in the name of the word. We got to think about who that trustee is going to be. One of the common questions that we get is, can that trustee be ourselves and not in this type of trust? Is the answer. Not in this type of trust. It's not a general rule of trust, but for the purposes that we're talking about today, for a Medicaid Asset Protection Trust, seeking to get 100% protection of your assets that you put into it after 5 years, the trustee cannot be you, but it can be a family member, a child, it could be a beneficiary, it could be anybody but you. Also, think about the beneficiaries and how we want to structure the plan, because when we talk about a trust, now we get more options, like you do with the will, to think about the beneficiaries, who gets what when, and on what terms. So with those transfers of the outright transfer and the life estate, you don't really get those. You get to put a name. It's kind of like a beneficiary designation on a 401k or a life insurance policy. Let's say the life insurance policy, if now child is disabled when they go to inherit the money, and it wouldn't be wise for them to inherit that money because the state's going to take it, simply having them listed as a beneficiary on the designation form is not going to do anything to protect that. But meanwhile, with a will or a trust, we have opportunities to protect and put some strings attached and contingent planning into the future. So if this is something that you're considering, you should seek help from a dedicated estate planning and elder law attorney. And the reason is for all the reasons we discussed about attorneys so far, is that I don't know why people do this. You would never go to your dermatologist and ask him to perform open heart surgery on you. And yet people ask their attorneys for that all the time. They ask their matrimonial attorney who handled their divorce. They liked them. They went to them to ask to handle their estate planning, and they ask. And for whatever reason, and I don't know why, that attorney will say yes. And that's the most dangerous thing a person can do. Meanwhile, in the medical side, I don't think you'll find your dermatologist willingly going into the operating room with you to do open heart surgery. So far today, you've discovered why outright transfers are not necessarily the best option. Yes, they can be simple, and sometimes necessary if we have no other options ahead of us. But because of the capital gains issues, because of the property tax benefit issues, as well as the irrevocability, the outright transfer doesn't happen to be one of the best options that we have for proactive Medicaid asset protection to protect the home. We talked also about how to avoid the major trap in the life estate, which is it looks simple, it sounds simple, but it provides this negative consequence of the irrevocability, in that we are really stuck with what we've done unless all the stars align and everyone cooperates in the transfer back if we need it to be, or the transfer and change of beneficiaries in the future. And last, we discussed how the Medicaid Asset Protection Trust, even though irrevocable, can provide the most degree of flexibility and protect your home without any of the negative consequences that accompany the outright transfer or the life estate. So if you get one thing from today's talk, because I know that we talked about a lot, and we're talking about it in a 10,000 square foot view and not exactly how it applies to each individual's circumstances. I hope that you get this one thing, that you can protect your money from the greedy hands of the government and make sure that your family is taken care of. And how does that get done? It gets done by taking proactive action to make sure that you know your rights, you know what your options are, and that you take advantage of them as early as possible. Now, we have an option to help you with this, and this is our Protect Your Home strategy session. Now, this strategy session is for you if you have a family. The reason is because we're a firm that works tightly with people who have families. Why is that? Because of the strong desire to provide for their children in a meaningful way. I've often had clients where they don't have to have children and they don't really care quite as much if the money goes to the state, because they don't have that connection. Not to say that if you don't have a family, we can't help you. If you have a strong desire to keep the money out of the government's hands, we can still help you. You've worked hard for your money and you don't want to see this cost of care at $18,000 a month. That's for each year right now, $216,000 a year get eaten up by long-term care if you had other options to plan. If you want to protect that money for your family, that is what we can help you with. Now, what is this session and how does it work? Now, it is a 1-hour meeting where we can meet one-on-one, exchange your confidential information, and give you actual legal advice and a plan for you to be able to protect your assets. In that, we will discuss your desired legacy. Now, we've done plans from the most simple to everything to my 3 kids, equal shares outright when I pass away, to someone who wants to leave a house behind for a surviving second marriage spouse to live in and make sure that the children can't take the house or force that spouse out immediately upon passing. We've had children that or clients that want to leave money to their grandchildren to start a scholarship fund, so to speak, to be able to pay for college because they placed a great deal of effort and care on education. We'll also explore which of these options are the best asset protection plan for you. Look, none of this is a one size fit all. Why we started the presentation today by talking about how this is not legal advice, because maybe your best option is an outright transfer. Maybe it's not. Maybe it's a life estate. Maybe it's a trust. We tend to see most proactive planning. You have all 3 options, but most proactive planning, people will either rely on the life estate or the Medicaid Asset Protection Trust. After considering the irrevocability, they consider the Medicaid Asset Protection Trust to be one of the better options. But by no means do I recommend anybody rush out of here today to go create a trust or to do a life estate deed or an outright transfer. We often find then there's also issues that are intertwined with these that we've been procrastinating on. Look, nobody wants to talk to this, and I applaud each and every single one of you for being here today on an otherwise beautiful sunny afternoon, especially after a rainy day yesterday, to talk about death and assets protection and illness and nursing homes and so crazy stuff, right? But these are things that are there. If we choose to keep them in the closet, they're still there. We may not see them until you open up that closet door and everything falls out again and you shove it all back in, but it's there. Plus, we will answer the questions you have about your unique situation. Today, we will be able to answer questions, although if I may caveat by saying that we need additional information or answering general questions today to answer how Medicaid works, how asset protection works, questions about the trust, but about your unique situation because of I can't give legal advice over this format, and you don't want to give me enough confidential information over this format to be able to give you meaningful advice. We can address those questions. At the end of that 1 hour session, you will know your options in more detail and other options you might have beyond the 3 that we talked about today. You'll also be informed exactly what to do next. Okay, so you'll have actionable items. You'll have an estate plan, right? You won't have the trust, you won't have the deed transfer, but a plan to actually protect your assets and protect your legacy. Now, at the end of that session, it's 100% up to you. You can hire us to implement that plan. So, for example, if you wish to create the trust that is recommended after consultation with you that day, we can do that. You can also go to someone else to do it, right? And so, after our meeting, if you decide to have us do it, just to tell you a little bit about our estate planning process, because this stuff is so important to you and your family, and it's so customized, we schedule a design meeting. It's impossible to try to tackle all of the things that you need to know, or the things that you want to design, the bells and whistles, the options, in one meeting. So we do that in our next meeting, which will be our design meeting. After that design meeting, we leave with a blueprint that we can then go ahead and prepare your customized plan. And in that next step, then we will review that with you. It'll be about another hour meeting. And I use this because I can't stand it. Now on my phone, I can go to get my blood work done. And on my app, it'll tell me the results of my blood work when I'm all done. And it gives me some green lights and things. And I look at that and I have no idea what that stuff says. You might say, or how do you not know? I don't know what it says. I didn't go to med school. I don't do this every day. I do law. I do estate planning in particular. And so I like to sit down with the doctor and have them explain that to me. It's the same concept here. Many law firms, many attorneys, I find that people complain about the issue is they send them a stack of 400 pages of legalese, right? The stuff that I went to college for, I went to law school for, and the things that we practice every single day, I send it to you and say, take a look at it, tell me when it's good to go and when you're ready to sign. So that's not how we work things here. We'll sit and go through each step of the plan with you in as little detail or as much detail that you need. We've had clients want to read through every single line of the trust and have questions about every single section flagged up. And by all means, we want to help you with that. Or some that just want to know, how is this fitting into my major objectives? And we'll be glad to do that. The third then will be our implementation meeting, which is where we'll go ahead and sign everything. That in of itself, we find that clients go ahead and compare to a real estate closing. They say every time they've never signed as many documents as they have today since they bought their house. And then there's usually a race. We try to make a nice fun meeting, usually a race between the husband and wife to who can sign first. And we often always find that the wife wins. So don't bet on the husband. And then lastly, we have our peace of mind program for those that continue to want ongoing advice instead of transactional relationship with their advisors. And that's where we can continue to help you with updates that affect your plan, both that you desire or plan updates that are required by the laws changing around you. For example, the nursing home or the home health aid look back period changing overnight from 0 months look back to the 30 months, 2.5 year look back period. And for those clients that are in the peace of mind program, we do help them with an ongoing relationship to do that. Now, this session is a total value of $450, but for those that register from this webinar, we are going to go ahead and discount that to $250. You'll save $200 there, and that will be the cost of that strategy session to take a look at your particular needs. Now, I put up here a link for you if you'd like to go ahead and schedule that planning session, which I sincerely hope that you do, to see how this fits into your needs. You can do that by going to www.startplanningnow.com, or if you happen to have your phone handy or an iPad that has a camera, you can put this up on your camera here and scan this code. It'll bring you right to that page, and on that you can go ahead and take a look at the availability that we have. And really, what is the catch? And that's that we, in the next 2 weeks, only have 8 spots available. There's so much going on in the law right now with tax changes and the community Medicaid changes that it is incredibly top of mind for many people. So there are only 8 spots available there. So if this is something that you are looking to do, I recommend you go ahead and grab that there. You're going to go to www.startplanningnow.com or schedule or scan that code there. Now, I will guarantee to you that when you leave that, and we do this for, we'll do this for everybody in the webinar, you'll know your options. You'll have an actionable plan that you can protect your family with. I mean, you can go and say, I want to go hire someone to do piecemeal each one of these things, or you can hire us to do this for you. I will also give you a money back guarantee on that $250 consultation fee for that strategy session, that if you don't feel that you received the value for that hour session, that I will give you the $250 back. I stand by it, that 110% that know that you will walk away and knowing that. I'll also go ahead as well for anybody from today's webinar is go ahead and apply that 250 to you, to your case work that you happen to have done. If you do decide to move forward with a plan, for example, if we were to be engaged for additional legal work after that strategy session, what we will do is apply that 250 as a discount credit to the session. So I want to open the floor to Q&A. I want to turn it over to you, Courtney, if we have any questions in the Q&A, or if you haven't entered any in yet, I ask, go ahead now, and there's a great time to do that. Be glad to answer questions that you have.
Yeah, once again, the Q&A is at the bottom. You can put them in there. We see one question right now: is an revocable trust enough to do what we mentioned today?
So a revocable trust as an RE?
Yes.
That's a great question. So revocable trusts definitely have their place in Medicaid planning. We often use them the most, though, where we are not doing proactive planning. Like everybody here in today's webinar is sitting here in advance to try to protect and get 100% savings and protection on the money that they transfer to this trust. Sometimes that's not always an option. And so a revocable trust can fit nicely. And where a revocable trust can help is only really with your home. And that's a great question, because that's the topic of today's talk. If, for example, client never needs a nursing home, never. Let's say we had 100% crystal ball guarantee, never needed a nursing home ever in the future, neither spouse, a revocable trust can work just nicely. The reason why this works comes from an examination of two major components of Medicaid planning. One is eligibility, and then two is recovery. Now, eligibility, what does that mean? That means, can I qualify for Medicaid? Can Medicaid start paying the bills, so to speak? If I go, let's say I'm going out for a drink after work, can I get the bartender to start pouring drinks, right? But recovery then is that bartender is going to come back to someone with the tab, right? And someone's got to settle up. And that's what recovery is. The reason why the revocable trust can work in those circumstances for a client is because in New York, a person, when they're on home health care, is allowed to have a home. It's not counted towards the equity cap. The equity meaning that you're not allowed to have more than $15,900 in total assets if you're actually applying for Medicaid right now. That's all you're allowed to have in your name. But the house's equity is not counted towards that. So actually, if you just left the house alone and got community Medicaid, you could get it, whether it's in your name or in a trust. Where the trust then starts to help then is in the recovery component. After you pass away, how do we stop the state from coming back with the tab? Let's say that for 3 years, they ended up paying out $650,000 of care. I mean, that's 18,000 times 36 months. So if that's the case, then what would happen is that the state would be able to come after a person's what we call probate estate. And the way we can avoid them coming after that is to have it in a revocable trust. Okay. And they can now be eligible for Medicaid, and the state cannot recover against the house. But this only works if neither neither spouse needs a nursing home, because once you go into a nursing home, now the state's going to want to file a lien against the house while you're still alive to secure their right to the tab, kind of like giving your credit card over at the bar. right? And so they are going to require that. And so it doesn't protect against the nursing home. Okay, so there's some limited protection options with irrevocable trust. And we often use those where a person comes in a crisis mode, meaning let's say that a person came to me today with no available transfers they could make. This would probably be our only option with the house right now, and hope that they never need a nursing home because we can get the home health care at home. Great question.
We have another question here. If you already have a trust, but your house is not in the name of the trust, how does the look back period work if you now do the transfer?
That's a great question. So unfortunately, very common, something that we see, people get trust created by attorneys, and then they don't include in their process funding the trust. And so that is part of our process for that very reason. But what happens there is that you've simply created a trust, and because you never actually transferred the home to the trust, you never got the look back period starting. Okay, so what I would do for your particular circumstance there is I would, before transferring the house to the trust, let's examine your options right now. I think that also comes into examining that trust. Since it's not being used yet, let's actually make sure it's good for its intended purposes, because there's no such thing as really a Medicaid asset protection trust. We're calling it that. I'm calling it that because that's the accomplished goal of it. If you call, you see a Google about trust, there's all these names about trust, like irrevocable life insurance trust, right? Qualified personal residence trust. They're all just named, colloquially about the actual thing that they do, but you actually have to know how to draft one. And one provision wrong in the trust can make the whole thing not work for its intended purpose. For example, we've seen trusts come through that are Medicaid asset protection trust, but name the client, right, as the trustee. That is going to make everything inside the trust available for assets. So first, I would take a look at that trust, and if that trust is still good and matches what will help as a vehicle to protect the house, if you transfer the house to the trust now, what will happen is it will start a clock, so to speak, from today. Let's say we were doing this transaction today, so we do that today. The look back, all right, the protection clock would not be run out, right? The house would not be fully protected until 5 years from today. It's not going to be 5 years from the date you created the trust. Not going to be 5 years from the date you thought about putting the house into the trust. It's going to be 5 years from the date of the deed, right? So we create a deed, we do the transfer to the trust. It's going to be that date. And 5 years from then is when it gets protected. So if you're concerned about this, this is something that I would do now for a couple of reasons. One, because the clock is ticking, right? We just don't know what the future will bring. If I had a crystal ball, I think I'd be somewhere warm on a beach somewhere with a margarita, I think. Yeah, sounds pretty good. And maybe in a hammock taking a nap too. But I don't have that, right? And so we don't know what the future will bring. Also, the law changes. The way that they've been handled is to grandfather in those people that made the actual gifts, the transfers, under the previous law. So for example, with the change in the home health aid look back, people that made transfers before the October 1st announcement date, of the effective date of the new law, those people, even if it was September 30th, were grandfathered in. Okay, they're not going to get that 2.5-year look back applied to them because the law changed to increase it. The state put everybody on notice. The people that took advantage of that notice are going to get the benefit of it. The ones that didn't are not. And so we see that being an issue right now. It's also uncertain still with the look back for the home health aides because of the pandemic. The state said as of October 1st, it's going to be in effect, but the pandemic has prevented them from actually implementing that look back period. They then said they are going to go for April of 2021. Naturally, the COVID didn't clear out by then. Then they said July, and that's currently what they say now, but the pandemic is still there. Nothing has changed. In fact, the federal government has said that it will be there till the end of the year. So we anticipate, 2021 is this time to kind of clear up these gifts and get them to the trust. Also to start the look back period for nursing home care now instead of waiting 5 more years. But also if that does get extended as well to 7 or 10-year look back period is always a possibility. Those people who planned ahead will be likely, can't guarantee anything, if we take history to see how things will work out in the future, then they will be grandfathered in as well.
Okay,
Very good.
that seems to be all the questions we have, but of course, as additional ones come in and you have any
Yeah.
questions, it would be great to discuss it in a consultation specific to your situation. And again, you can use the QR code by using your phone. On the camera setting, you should be able to click the link that pops up that the QR code generates. It would take you directly to that link to find a consultation that works at a time for you.
And Courtney, I put this up here for everybody. If they're still on the fence, if this is what nudges you over to get you, to do a sweeten the pot with a $10 gift card for Starbucks if you like coffee like me, then you'll get that as well. For those that were on today's call that do go ahead and book one of those sessions. And again, we will apply that $250 towards your plan. So remember that actually then does not cost you anything. So again, at the end of that session, you'll know what your home protection strategy is. We'll also talk about your other assets and seeing how we can protect assets. For example, stocks and bonds and life insurance are great things to talk about and how they can be protected. And those actionable steps to actually protect your home, give you the customized legal advice that you need. And the key, going back to that last question that we talked about, was getting ahead of the look backs. So that question, why now? And why you're all here today, because we know there's a look back period, and those that plan ahead will hopefully reap the rewards of that benefit. I say hopefully because there's things that change in the future. I gave you Hannah and Jack's case study that frustrate those purposes. But if we can get ahead of the look back periods, plan early, we can really see 100% protection of assets that we plan with. So thank you all for attending today. We'll keep you in the loop for additional content that comes up. Did everybody find this helpful today? If you did, just please drop a Y in the chat. It's so odd to be staring at this camera, but I'm getting, I've gotten the hang of it, but it's still, I miss everybody. So it's my way of interacting. Thank you. Yes, fantastic. All right, well, very good. Thank you all for attending today. We look forward to helping you in the future. Thank you, Courtney.
Thank you.